Citizenship. Overview and privileges given only to citizens of India. Citizenship Act 1955. Acquisition of citizenship. Loss of citizenship. Single citizenship. Demerits of double citizenship. Overseas citizens of India. Article 5. Citizenship at the commencement of the Constitution. 6. Article 6. Rights of citizenship of certain persons who have migrated to India from Pakistan. Article 7. Right of citizenship of certain migrants to Pakistan. Article 8. Right of citizenship of certain persons of Indian origin residing outside India. Article 9. Persons voluntarily acquire citizenship of a foreign state not to be a citizens. Article 10. Continuance of the rights of the citizenship. Article 11. Parliament to regulate the right of the citizenship by law. Introduction. India has two kind of people, citizens and aliens. Citizens are full members of Indian state and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all civil and political rights. They are of two categories: friendly aliens or enemy aliens. Friendly aliens are the subject of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subject of that country that is at war with India. They enjoy lesser rights than the friendly aliens. Example: they do not enjoy protection against arrest and detention. Article 22. Rights and privileges given only to the citizens of India. Right against discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. Right to equality of opportunity in the matter of public employment. Article 16. Right to freedom of speech and expression, assembly, association, movement, residence and profession. Article 19. Cultural and educational right. Article 29 and 30. Right to vote in the election to the Lok Sabha and the State Legislative Assembly. Right to contest for the membership of the Parliament and the State Legislature. Eligibility to hold certain public offices, that is, President of India, Vice President of India, Judges of the Supreme Court and the High Courts, and the Governor of the States, Attorney General of India and Advocate General of States. Note: in India, both a citizen as well as naturalized citizens are eligible for the office of the President, while in USA, only a citizen by birth and not naturalized citizen is eligible for the office of the President. Constitutional provisions. The Constitution deals with the citizenship from Article 5 to 11 under Part 2. It only defines that it only identifies the person who becomes citizens of India at its commencement on January 26, 1950. It does not deal with the problem of the acquisition of or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, following laws were brought about. Citizenship Act 1955. The Citizenship Act provides for the acquisition and the loss of citizenship after the commencement of the constitutions. This act has been amended many times by the following acts: the Citizenship Amendment Act 1986, 1992, 2003, 2005, 2015. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act 2003. According to the Constitution, for the following four categories of the persons become the citizens of India at its commencement, that is on 26 January 1950. Domicile who migrated to India from Pakistan, migrated to Pakistan from India, but later returned. Overseas Indians. Article 5. A person who had its domicile in India and also fulfill any one of the three conditions: if he was born in India, if either of his parents was born in India, if he has ordinarily resident in India for 5 years immediately before the commencement of the Constitution, become a citizen of India. Article 6. A person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfill any one of the two conditions. In case he migrated to India before July 19, 1948, he had been ordinarily resident in India since the date of his migration. or in case he migrated to India or on or after July 1948, he had been registered as a citizen of India. But a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for registration. Article 7. A person who migrated to India from Pakistan from Pakistan from migrated to Pakistan from India after March 1, 1947, but later returned to India for resettlement, could become an Indian citizen. For this, he had to be resident in India for 6 months preceding the date of his application for registration, and also Article 6 to be followed. Article 8. A person who or any of whose parents or grandparents was born in uninhabited India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or the consular representative of India in the country of his residence, whether before or after the commencement of the Constitution. Thus, this provision covers overseas Indian who may want to acquire Indian citizenship. The other constitutional provisions with respect to the citizenship are as follows. Article 9. No person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign states. Article 10. Every person who is or is deemed to be a citizen of India shall continue to be such citizen subject to the provision of any law made by the Parliament. Article 11. Parliament should have the power to make any provisions with respect to the acquisition and the termination of citizenship and all other matters relating to citizenships.